Welcome to the Wheelbarrow Profits Podcast, where you get multifamily investing made real. Learn from top players in the real estate investment world as they share their secrets with you and discover proven strategies on apartment investing that actually work. To learn more about Wheelbarrow Profits, visit jakeandgino.com, your one-stop shop for everything multifamily. Now to your hosts, Jake and Gino.
Hello, everybody. This is Jake Stenziano, host of the Wheelbarrow Profits Podcast, here with my co-host, the multifamily mentor, the coach, the chef, the father of six, the best-selling author, the G-Daddy, Gino Barbaro. Gino, how's it going?
Mr. Stenziano, doing good today.
Very good. Well, listen, we got a great guest today. Today's guest is Jeff Love. Jeff is a multifamily syndication attorney, and today he's going to walk us through the steps of syndicating your first deal. So without further ado, Jeff, welcome to the show.
Hi, guys. Thanks for having me.
Pleasure to have you here. And why don't you just tell us a little bit about how you got into syndicating real estate deals?
Well, been a real estate, corporate, and securities attorney for about the last 7 years. All the areas are related. So when we started doing leasing and purchasing and sales, different deals, that led into more corporate work, which led into securities laws, because all of the areas are somewhat related. So I have different clients who would buy properties and then look for investors. So it just led us into doing more securities work.
That's perfect. That leads me right into my first question. What is a security and what are security laws?
Sure. Before I just get into the meat of your questions, I should do our typical lawyer disclaimer where I say that this information, I can't say it's legal advice, it's for informational purposes, that there's no attorney-client relationship between you or your listeners and our firm, and that any opinions I give are my opinions and not of any other attorney at the firm. And with that,
Gino, write that down so we can say that every time we're on the show now, too.
I forgot it already, Jake. Boy.
So a security... Okay, you want to repeat the question for me, Gino?
So what is a security and what are the security laws?
Okay. So a security is anything, a stock, a bond, a promissory note, anything that you are trying to raise money. Security law would be the 1933 Securities Act, which was created because in the early 20th century, they wanted to protect investors from essentially losing their shirt. And there was a lot of fraud without giving the investors the appropriate information that companies would hold back. Mm-hmm. So in 1933, they created the Securities Act of 33 and the corresponding Act of 34 with the purpose of protecting investors and making sure that they're on the same playing field with the companies, sponsors, syndicators, whoever was actually going out and raising money.
When do these security laws apply?
Securities laws apply any time that you're selling a security. So you're selling a stock, you're selling a bond, you're selling a membership interest in an LLC. Really, a good rule of thumb is any time that you are raising money and the investor is relying on you in your efforts for a return on their investment.
That's perfect. That makes total sense to me. That's going to dovetail into my next question. Can you tell me the difference between a passive investor and an active investor?
Sure. A passive investor is the typical investor we've been talking about, someone that would give you their money and help to rely on your efforts for return on your investment. So you invest in the stock market. You're a passive investor. You're relying on the company to do the work, and you receive a return on your investment. In contrast, an active investor is the company. It would be someone that's actually working, and their efforts are getting the return on the investment. So in our context of syndication, the sponsor or the syndicator would be the active investor if they're investing in the deal as well. And your typical investor, they're your passive investor. They're sitting back hoping to get a return on their investment based on your efforts.
Perfect. So when does a real estate offering become a securities offering? That's, I guess, the $10 million question because, you want to know, am I following the laws here?
Of course. Any time that you're raising money, that it's going to be a security, whether it's real estate or venture capital, you have to be aware of securities laws. And that's the sponsors, that's the real estate attorney, that's the $1 million question. So you really need to look at go back to our first question, what exactly is a security? And there's a test that you can look at. It's when you're investing money in a common enterprise to get an exchange or a return on your investment, relying on someone else's effort. So if you are trying to raise money and you meet that 4-pronged test, then you're selling a security, and in that context, your real estate offering would become a offering that's subject to securities laws. When you're not subject to securities laws is saying you have Jake and Gino, and you both are doing equal work in an LLC for a property investment. Neither one of you is just supplying the capital. Neither one of you is just supplying the work and the knowledge. If you're equal partners, then one of you is not expecting a return on your investment just for being a passive investor relying on the sole efforts of the other.
Yeah,
that's really the dividing line.
That makes sense to me. You had referenced the Securities Act of 1933. Can you discuss it just a little bit and how it affects raising private money?
Sure. So the Securities Act of 1933 is really the bread and butter of what are our securities in the United States. That's when you get into Regulation D and the common exceptions for private placements. Without an exception, any offering of a security has to be registered with the SEC. It becomes a public offering. When you get into big offerings, that's when you get IPOs and things of that nature. But in short, anything that's security must be registered with the SEC. So under the 33 Act, there are certain exceptions that you can use, which we'll talk about, I'm sure, soon, that essentially allow you to avoid registering with the SEC and avoiding a lot of the compliance issues, and really avoiding the 34 Act as well, 1934 Exchange Act, when you have to disclose a number of different items to your investors.
We have down here, Jake and I, we're wondering, what is a blue sky law? I've heard that before. Can you describe what that is?
So we go back to the same kind of thing. In the early 20th century, companies, individuals were more or less ripping off the investors that didn't know what they were doing. They didn't have proper information to really make a knowledgeable investment. So the term blue sky came from that era, when you have individuals that would try to sell people anything but the blue sky. That's the name, that's the blue sky. And what they did is, in California and other states in particular, they started to create regulations to protect investors that got codified over time into different state securities laws, which really led in the culmination of the 33 Securities Act. And even today, most states, if not all states, still have securities laws, but oftentimes there are different codes that allow the federal, the Securities Act and the SEC, to supersede state laws. So you can often comply with the 33 Act and not have to comply with each individual state's act, subject to certain exceptions, and making sure that both laws coincide.
I think, Jeff, this is an important question for a lot of listeners out there. They all want to find out, how can an investor solicit funds? What are the ways that they can solicit funds?
The first way that we've seen, from a syndication real estate attorney standpoint, is always family and friends. That's the first place you go to raise money for a real estate syndication, a business, anything. You go to the people that you know. From family and friends, I would contact your real estate local brokers and attorneys to really start getting a network of investors. And I'm sure you can expand on this, finding the investors, but it's really getting a network of investors and establishing a pre-existing relationship, which is one of the factors that you need to do a private placement when you're not using just accredited investors, is you need to have a relationship with these people. So the more you can go out and start a network of people that you know that may be interested, invested in like-minded people, is going to help you in the long run, because the more you know someone too, you want to make sure that if you are syndicating a deal, you're going to get into bed with the right type of people that aren't going to cause problems for you later on, and that they have the financial wherewithal to really stomach the investment and stay in there for the life of it, which could be 5 years, 10 years, even 20 years, depending on the hold period of the syndication. Network,
right, Jake?
Network, baby.
Get out there and network. Now, we're talking about the Reg D. Can you discuss when you can be exempt from full registration and discuss that Reg D a little bit for us?
Sure. So this is the main part, Regulation D of the Securities Act 33, where you would rely on to get a private placement. So to back up, you have the Securities Act of 1933 saying that all securities need to be registered if it's going to be an offering. Below that, you have a section called 4A2. And that is where Regulation D lies. That says as long as you are not an issuer with a public offering, that you can rely on one of these exceptions and not have to register your offering with the SEC. Under Section 4A2, that's where we have Regulation D. That consists of Rule 504, 505, and 506. There's also Rule 503, which pertains to intrastate offerings. If you were all your investors were in California or Florida, but given that most investors are just cross state lines, I think we focus on Rule 504, 505, or 506.
Okay.
So 504 and 505 are limited exceptions. They have caps on how much you can raise of $1 million and $5 million respectively. So most people tend to rely on Rule 506.
Okay.
That's what you're going to do if you want to do a private placement, which most syndicators or sponsors are going to rely on. And Rule 506 is divided into subparts. You have 506B and 506C. They're both under Regulation D. So being under Regulation D, you really don't have to file much with the state or SEC. There's a form called Form D, which is really the only form that you have to file with the SEC. It just lets them know, the simple form filed within 15 days of raising your money, lets them know that you are conducting a private placement, that you're meeting all the requirements, and that saves you a lot of time and effort rather than doing a public offering.
Sounds like you want to get someone that knows what they're doing. Because I'm lost in 504, 3CD, A12 already. You got me lost, man.
Really got into it. So you do want to get an attorney or someone knowledgeable that can guide you through these different exceptions because, as I said, as Jake mentioned, 504, 503, 505, there's different rules and each one has their different exceptions and criteria that you need to meet. I think for the podcast and for this purpose, just talk about 506, which I mentioned. Mm-hmm. 506B is pretty simple. You can raise an unlimited amount of money from an unlimited amount of accredited investors and up to 35 sophisticated investors. But you're not allowed to advertise to the general public. You need to have a pre-existing relationship with any of these sophisticated investors. And that's really the kicker between 506B and 506C is this general ability to advertise to the general public.
What's your feeling about sophisticated investors? First, give us a definition of a sophisticated and an accredited investor. And what is your feeling about including them in the deal, sophisticated investors?
So you really have three types of investors. You hit on two of them. You have sophisticated investors, accredited investors, and you have non-accredited investors. Basically, an accredited investor, the SEC puts out, it's like 8 or 9 different items which make you an accredited investor. Most people, they're only going to focus on 2. You would have $1 million net worth exclusive of your primary residence. You as an individual make $200,000. You have for the past 2 years. You're reasonably expected to do the same amount of income for the next year. Or if you're married, you and your spouse combined have made $300,000 for the past 2 years and have a reasonable expectation of doing so. So you either have the income or you have the net worth. And if you meet one of those criteria, then you are an accredited investor. A sophisticated investor, you don't meet the accredited investor standpoint, but through education or experience, you have a business background and you're able to evaluate the pros and cons, the risks, the benefits of a potential investment. Then you have a non-accredited investor, which doesn't meet the criteria for an accredited investor or a sophisticated investor. So you really, unless you want to get into, Rule 504, even I'm getting confused, 504 or 505, you're really going to stay away from unaccredited investors. Under Rule 506B, you can have sophisticated investors up to 35. 506C, when you do the general solicitation and advertising, you can't have any sophisticated investors. So if you plan on advertising to the public, that really answers it for you. You can only have accredited investors.
Gotcha.
Whether or not to include sophisticated investors is a decision that each syndicator sponsor will want to make. They'll need to have a pre-existing relationship with these sophisticated investors. And besides the legal requirements, you really want to have a background and knowledge about these people. Because if you have someone that's a first-time investor, or as the saying goes, a nervous Nelly, you really want to be careful, because you're getting into business with these people. And if someone is not sophisticated in these type of deals, they're the people that most likely are going to potentially cause problems for you in the future if they lose their investment, they didn't fully understand the risks. So that's just something you want to be aware of and know who you're getting into business with, whether you're going to use a sophisticated investor or a accredited investor, or rely on a different exception. You can go into business with an unaccredited investor.
So what's been your experience, though? Most syndicators, most guys you work with, do they like to include the sophisticated investors, or do they like to stick with accredited? What's been your experience with that?
It really depends on the deal. I'd say if you can fund a project using only accredited investors, that's the way to go. Because these investors are sophisticated. They know what they're doing. They meet the financial requirements to be an accredited investor. They've done deals like this in the past. And then you can really rely on 506C, and you could fall into that general advertising, or
Yes.
Talk about the deal on your website, or do social media and really advertise. If you can't get there, you don't need to use the advertising. Say you're using family and friends, and they've committed to you enough to fund your deal. You don't need to advertise, but maybe one of them are not an accredited investor. That they have $150,000 in net income or $800,000 in net worth, so they don't quite meet that, but they know what they're doing. They have a business background. You've known them for a while. Maybe they are a family. Then it's no harm to use a sophisticated investor, and you could rely on 506B to get your private placement and get your deal done that way. So I've seen it both. We work with a lot of syndicators, and it really depends on the deal. Maybe one uses a sophisticated investors in one deal, but another deal they use only accredited investors.
I think 506C keeps that creepy old uncle out of the deal, and you don't got to worry about it because you just can't let him in the deal due to the regulations, right?
It does, and that brings up another point. When you have an uncle or family member, putting aside the legal, even business requirements, now you have a family member in there or a friend that maybe you don't want to deal with. Maybe you just want to deal with other business associates, and you can keep people out of a deal by using a 506C. It's only accredited, and maintain face with them and maintain your relationship and say, I can't put you in this deal when you may not want them or any other reason, but you keep them and you put them in a separate deal. So it does give you some flexibility as well.
I like that. That's great. What information do you need from an investor? Now, they know about the deal. We're going to talk about what we have to give to them, but what do we need from them?
Depends on who the investor is. So let's go back to Rule 506B. If it's a sophisticated or accredited investor, typically you need a pre-existing relationship with that person. Remain under the SEC and the Securities Act of 33, to get that pre-existing relationship, you need to know the person. You need to know what their investment requirements are. Make sure that they have the funds to put their money in this investment and leave them there for the term of the deal. So you really can't meet someone on a Monday and put them in a deal on a Friday to meet this pre-existing relationship. You need to know their financial background, and you really need to have a track record establishing that relationship. That's how you would meet the pre-existing requirement and essentially know that they're a sophisticated investor. Under 506B, you're allowed to just use a questionnaire to verify this. You can have, when you get their address and their name, however they're going to subscribe to your interest in the company, you can have them represent that they're going to be a sophisticated investor or an accredited investor. If they're going to be an accredited investor, they can check the box that they have that $1 million net worth exclusive of their primary residence, or they and their spouse make $300,000 a year. In contrast, in a 506B, you need to take reasonable efforts and steps to verify that an accredited investor is an accredited investor. So the law makes you go one step further. You can't just have this person fill out a questionnaire that says they're an accredited investor and you can rely on that. Instead, you need to verify their status. You need to look at their tax returns and see their income, or look at financial statements, or get the confirmation from their attorney or accountant. Take reasonable steps to actually verify their accredited status. So depending on which exemption you rely on, there are little, minutia, but there are differences between what you need to do to verify their status as an investor.
Gotcha. So Jeff, what constitutes an offer?
An offer is really any time that you're giving the transaction-specific details to a person soliciting their investment. So if you have a deal in mind and you go to a person and you give them details about this and let it know that you're looking for an investment would constitute an offer. So what many investors, syndicators and investors do to just get a preliminary level of interest is don't give the specific details. We're looking for a multifamily investment in Nashville, or I'm going to solicit investors for a future deal. You can't give them everything. So get rid of the transaction specific details, or don't specifically let on that you're looking for an investor in that specific deal. Because once you combine all of the factors, then you're really making an offer. And to do that offer, you need to comply with securities laws and give them the proper paperwork.
Now that Jake and I are lost through this whole thing, I think this is the important question. What documents do you prepare in this whole scenario here? Let's go through the PPM, the operating agreement, the subscription agreement.
So these are the documents that you use and that we prepare as attorneys to let you meet all of the requirements to meet your private placement exemption, to meet the 506B or 506C that we've been talking about. Private placement memorandum is really an offering document, somewhat similar that you'd see in a registered offering. And you're going to disclose all the risks. It's really the roadmap to the investment. You might talk about a summary of the offering, what returns that you're projecting. Obviously, you're not going to guarantee them, but what you're projecting, who's going to manage the entity, what's the property, what are the specific details of the property, are there tenants there, if it's a commercial deal, if it's a retail deal, who's the tenants. You're going to talk about, typically the sponsors will talk about themselves, and there may be a bit of a background to give their investors some comfort about who they're investing with, who's going to manage the deal. You'll get into the legal risks of real estate. There are risks associated with real estate, construction, there are environmental risks, there are business risks. This is a new venture, doesn't have an operating history. Really lay out all of the risks and disclose, because this is the document that you rely on. So an investor's not going to sue you for fraud or for omitting the material facts. Important caveat here is that even if you create an entity, an LLC or a limited partnership, there's no protection from securities laws for fraud or material omissions. So your PPM is how you protect yourself there, and you're going to disclose all of the risks you can to your investors. And even if you scare an investor a little bit, it's good because you want them to know the risks going into this. So 6 months down the road, they don't come to you and say, Jake, you didn't warn me about this. You didn't warn me about construction. And that's the type of person that might be litigious or come after you. You want to be able to say that I disclosed all the risks that I knew about in this PPM.
The more the better. Basically, get as much in there as you can so that nothing is left out, right? To get as many risks as possible, pile on.
Exactly. Because over disclosing the risks isn't going to hurt you. Maybe you lose an investor, which we hate to do, but you'll find another one that will be acceptable with the risks, and liability and future litigation costs, if it were to come to that, are far going to outweigh the cost of you finding another investor or doing it right the first time around.
I agree.
So as I said, the last part of besides these risks, you're also going to disclose the nature of the contractual document. If it's an LLC, your operating agreement, if it's a partnership, your partnership agreement. You oftentimes will summarize some of the key provisions and also put that in a private placement memorandum. So it really completes that roadmap, summary and risks. Someone can read that and really have a good idea of what they're getting into, what the investment's going to be like, the mechanics of how it's going to be run, things of that nature.
And the subscription agreement?
So the subscription agreement is how an investor would subscribe to the venture. It usually contains a number of representations that the company has only made so-and-so disclosures, that the investor is not looking to resell the investment immediately, that they have read the private placement memorandum and are acknowledging it. They know that the offering hasn't been reviewed by the SEC, that it's a private placement offering. It's really just, it's how they write their check. They're subscribing for 25% interest in your LLC that's going to buy 123 Main Street. That's the document that they sign, and that's how you get your binding commitment that they're going to subscribe to your offering, and they're going to write you a check.
So what's a typical time frame to prepare all this stuff? This seems like there's a lot of moving parts going on in this.
So it usually takes about 2 to 3 weeks. And the one document that we haven't talked about yet is really the legal agreement, the operating agreement, or the partnership agreement. Mm-hmm. That's going to take a fair amount of time, along with the private placement memorandum, because you want to disclose, and the operating agreement is going to contain how profits are distributed, how the company is liquidated, who's going to manage it, what are the manager's rights as an investor, what right do I have to vote on certain company matters, can I vote on a new tenant or removing a tenant, if it's multifamily, can I vote on evicting a tenant, or are those matters really left up to the manager or the general partner of the company? But even given that, 2 to 3 weeks would be a typical time frame, and a lot of that is back and forth with the sponsor or syndicator, getting background information on them, getting deal-specific business terms, which would come from the sponsor that we would put in the private placement memorandum, making sure that all the T's are crossed and the I's are dotted, and also need to leave some room for you as the sponsor, the syndicator, to review the documents, which can be cumbersome. We've seen PPMs, like I recommend, but on the shorter side, 10 pages up to 80 pages, really depending on the type of investment, the type of investors that you're going to have. Then tack on the operating agreement, which another rather cumbersome document laying out all of these rights of the investors versus the management, and then the subscription agreement as well.
So Jeff, I'm going to do syndication. I go to Jake. Jake, we have got to hire Jeff to do this. And Jake is Mr. Cheapo and says, I ain't paying for that. I'm going to do it on my own. So I want to pay it. He doesn't want to. We don't do this. We don't get all the paperwork and everything done. What are the perils if we don't protect ourselves and get all these documents taken care of? What can happen to us?
There are a lot of risks and a lot of pitfalls that we've seen in investors and sponsors face when they don't do it the right way. One, to get rid of your cost issue. A lot of times when you pay the legal fees up front or you pay your accountant to do information, well, most of those fees are recoverable through your syndication. It's costs of incorporation and setting up the entity. Your investors will often pay those costs through your syndication documents, so you'll be reimbursed. A lot of times, like we've talked a little bit about litigious investors or litigation, that doing it wrong up front is going to be cheaper than having litigation. Because if you get stuck with litigation, if someone sues you, you're going to spend a lot more money than the relatively cheap cost of forming it the right way. Mm-hmm. You also get into a lot more serious issues. If you don't disclose all of the risks, your investors could sue you. And they can sue you for rescission, which is not just the cost of litigation, but they can get the costs, they can get all their investment back. If they're damaged in any way, they can go after those damages. If you committed fraud or you had a material omission about a fact, there are criminal penalties that you could face. And it's just doing it the right way. If you do it the right way up front, you're going to save money in the long term.
I totally agree with that. Jake and I have been kicking around this idea of syndication and setting up a private equity fund. Can you just real quick describe the differences between the two of them and maybe a pro and con of each of them?
You're right. So a lot of people call them different terms. Real estate fund, syndication. Other term people often use is a blind pool fund or a specific offering. Mm-hmm. So the blind pool fund or the fund is when you're raising money without a specific project in mind. So use yourself as an example. So Jake and Gino want to raise $1 million to go out and buy a couple multifamily buildings. They're going to buy them on the cheap. But they don't have those buildings in mind. So they might go out to a few investors and say, we want to raise $1 million. We're going to look for multifamily in Nashville, Tennessee. That's a fund or blind pool fund because you don't have a specific project in mind. The downfall of a blind pool fund, and really the difficulty in it, is investors are relying on your track record. They don't see the property-specific details. They're writing you combined $1 million check to invest in properties that they don't really have control over. You as the sponsor are the one that's going to choose the property. So they're really relying on your track record. So to do a blind pool fund, you need to have a track record to be able to solicit money from investors, or you need to pair up with someone of experience and someone that does have a track record. We were able to pull in these funds and get these investors to write you essentially a blank check. In contrast, whether you call it a syndication or a specific offering, typically is a specific property that you are going out and trying to syndicate. To use our Nashville example, you have a 200-unit multifamily building that you're raising, again, $1 million for. Here you can actually go out and tell your investors the specific details, where it is, who the tenants are, what's the vacancy rate and the cap rate and all the different business and real estate terms, and they can make a decision whether to invest or not. So while they're relying on your experience to manage the property, they're not relying on your experience to pick the property as well. They know exactly what they're going to invest in. That makes it a little easier to syndicate and raise funds for that deal because an investor has more control, more knowledge about what they're investing in. One isn't better than the other. It's really a matter of the type of investors you're going after and your ability to solicit and raise those funds.
Gotcha. That makes a lot of sense. Before Jake gets over to his fun questions, I just had one. My last question was about crowdfunding. You hear a lot about crowdfunding right now. Do you have any thoughts or any concerns with the crowdfunding platform?
I do have concerns. So the crowdfunding came about as a result of the 2012 Jobs Act. And that softened a lot of regulations for raising money. That's actually where we get the general advertising for 506C. Before the Jobs Act, you couldn't advertise. Now you can. It also created crowdfunding. And that really, crowdfunding as a general term, really just means that you're going to raise smaller amounts of money from a lot of different individuals. Mm-hmm. One of my one of my concerns with crowdfunding is you don't really have that personal relationship with your investor. You don't know as much about them. And it's much more of an administrative burden to raise little amounts of money from 100 people rather than larger amounts from 10 people. When we talk about crowdfunding as a general sense, a lot of these real estate crowdfunding websites that are popping up, it's a little deceptive because a true crowdfunding scenario has significant restrictions on how much an investor can invest. You have $1 million maximum that you can raise, and depending on the income levels of certain people, let's say you made below $100,000 a year, you could contribute a maximum of $2,000 or 5% of your income, depending on the scenarios of the project. So that really limits what you can raise. Websites also, typical times when they're raising more money, they're relying on 506C. They're just doing their general advertising, but they're making sure that you're an accredited investor. And the accredited investors are investing in these bigger deals and then investing as little as $5,000 or $2,000. That's when they're really doing the crowdfunding on smaller projects. So
gotcha.
Ability to raise funds. But when you say crowdfunding, the syndication deals we're talking about, you could crowdfund that as well. If you were, say, buying a $100 million property, you would maybe have many investors that are contributing a few $100,000, and you are also crowdfunding. It doesn't have to be small amounts, but when you think about crowdfunding in the typical sense, investors often think about these websites that are raising smaller amounts of money from many people.
Got it.
Gotcha.
What about if someone wanted to hire you and say they live in Alaska or they are in Florida? Can you work throughout the entire U.S.? Yes.
So we're only registered to practice law in California, but we can do syndications all across the country. It's a federal law, so we can help a Florida entrepreneur with investors in Nevada and Tennessee. In fact, our firm also has a big international practice. So we've helped investors from other countries actually invest in various and various syndications. So that's a good question. We're licensed practitioner, but we can help investors all over the country.
Say we had a $5 million, $5 to $10 million deal. We're syndicating it. What would the typical fees be on something like that? Ballpark.
Usually probably around $10,000 to $15,000.
Yeah.
Which again is upfront cost, because what we're doing is we're creating that private placement memorandum. We're creating the operating agreement and the subscription agreement. The documents don't always vary by deal size or the amount of investors you have. Whether you have 2 investors, 1 investor, or 100 investors, you're still going to have the same private placement memorandum because you're selling a security. And to sell that security, you need an exemption from the Securities Act of 1933. What will save time and money is your operating agreement. If you have 1 investor, 2 investors, will often be a lot less complex than if you had different rights for different investors and you have many investors. Then you have a much more complex operating agreement. Also, the more investors you have, the more paperwork you're going to have, the more subscription agreements you're going to have, and just the amount of paperwork you're going to have.
Do you recommend any books for people to read that are interested in real estate syndications, or do they just call Jeff and get it over with?
Well, first I'd recommend you come to your blog to learn about syndication.
Oh, here we go.
The legal aspects of syndication, as you've talked about, there's all these different rules and exemptions. So it's a good practice, at least on your first syndication, to come to a knowledgeable attorney, whether it's us or someone else, to help guide you through the process. Because if you blow your exemption, then your whole deal can fall apart and you can be legally liable, both criminally and civilly, for returning the investors' investments for damages. Because if you, as we talked about, there's Rule 504, 503, 505, 506, 506B and C have different requirements. The amount of money you're raising is different for all of these. You want to make sure that you're doing the proper requirements to make sure that the investor, if they're sophisticated, that you have a pre-existing relationship with them, if they're accredited, that they've complied with the requirements, or if you're doing a general advertising 506C private placement, that you've taken reasonable steps to verify their accredited status. So even if it's just to talk to one attorney to make sure you're on the right path, it helps to make sure that you're not only picked the right exemption, you're meeting the right requirements, but for your actually operating entity, that you've picked the correct entity that's going to minimize your taxes, whether you're doing a limited partnership or LLC, that you're not using a C Corp in most situations, that you've picked the appropriate state to form your entities. Really make sure that you have all of the legal documents, all your ducks in a row, and that you've talked to someone to make sure that you're using the correct documents.
So what's the best way for listeners to get a hold of you?
Best way to contact me would either be through email at jlove@gibbsgiddon.com or by telephone 310-552-3400.
Jake, this is a full disclosure. We've been looking for a really great lawyer for the last, I don't know how many months, Jake. We finally found one, and I think what constitutes a great lawyer is someone who's knowledgeable, but someone who is really, I guess, generous with their time. Jeff spent a lot of time with us going over the laws and going over our whole scenario. He's been really generous with his time. He really knows what he's talking about, and I'm excited that we had this call because there's a lot to flesh out here. There's a lot of stuff and a lot of moving parts, and I think anyone who's an entrepreneur knows the value of hiring a good attorney.
Here. I like it. And I'm done talking about 504s and 606s and all that stuff today, man. My head's spinning right now. But that was a tremendous amount of value. So, Jeff, really appreciate the time. And for the listeners out there, if you guys found value in this, please get on iTunes, subscribe, and leave us a review.
Thanks, Jeff.
My pleasure, guys.
We trust that you enjoy the Wheelbarrow Profits podcast. Visit jakeandgino.com, your one-stop shop for everything multifamily. See you next time when Jake and Gino share more of their investing secrets with you.